Morning everyone. Today my quotation is प्रसन्न रहना बहुत सरल है लेकिन सरल होना बहुत कठिन है. चलिए इन्हीं कोटेशन के साथ क्लास को स्टार्ट करते हैं. और टुडे माय टॉपिक इज कंपैरेटिव स्टडी ऑफ CRPC विथ BNS. When we study the BNSS with the in comparison of the CRPC, we must have to retain the 17 or 18 aspect in my mind. The first is structural comparison, second is procedural shifted, third is on the basis of FIR, investigation, arrest, bail, trial, charge sheet, victims and witness protections, evidence and technology, sentence and penalty, security of the proceedings and preventive actions, proclamation and attachment, plea bargaining, maintenance proceedings which is earlier specified in section 125, appeal and revision, and some aspect relating to miscellaneous. But first question is comes in my mind कि when the BNSS come into operation, the 1st July 2024, and why BNSS is required for the Indian judicial system. Because the modernized criminal procedures is required due to the change in technology, due to the change in the procedures of arrest, due to the change in the procedures of FIR, and integration of the technology and digital reforms in India. Now my first topic, because today I am doing the comparative study of the CRPC with the BNS. My first topic is structural comparison. When we compare with the CRPC with the BNSS, earlier provisions, it means CRPC containing 484 sections, and BNS now having 351 sections. Earlier CRPC containing 2 schedules, but the same schedules are maintained in BNSS. If you are talking about the arrangement of this BNS and CRPC, CRPC is completely based on the colonial concept. औपनिवेशिकवाद पे आधारित ये हमारी संहिता थी. जब हम BNS की अगर बात कर रहे हैं तो BNS जो है, BNS हमारी कंप्लीटली स्ट्रक्चर बेस है मॉडर्नाइज सिस्टम पे. और हम क्योंकि स्ट्रक्चरल कंपैरिजन की बात करें तो स्ट्रक्चर में हम ये कह सकते हैं कि दिस इज ए रीअरेंजमेंट ऑफ द सेक्शंस ऑफ अर्लियर CRPC. And in the comparison of the structural comparison, we must have to explain the new terminology which is integrated in the BNSS. जब हम CRPC की बात करते हैं तो CRPC में हमने एक्यूज, इंक्वायरी, चार्ज शीट, इन सब चीज़ों की बात हम करते हैं. लेकिन जब हम BNS की बात करें तो उसमें नए नए टर्मिनोलॉजी को लाया गया, जैसे फिंगरप्रिंट, फुटप्रिंट, वीडियो कॉन्फ्रेंसिंग, जीरो FIR. These all are new concept which is integrated in our BNSS. This is a structural comparison. Now we discuss the philosophical shifted. What is difference between CRPC and BNS on the basis of philosophical thought? Basically, earlier CRPC is based on court-centric. It means paper-based proceedings are the key theme of the CRPC. But BNSS is completely based on techno-friendly, tech basis. That means victim-centered study is done in BNSS. Philosophical thought, I am already told. Terminology, already I am told. Time-bound justice is one of the philosophical shifted in CrPC to BNSS. When we talk about the time-based judgment system, in CrPC, no statutory deadlines are given, but BNSS having the strict deadlines relating to investigation, relating to trial, relating to judgment and appeal also. Now my third topic is FIR. When we study the FIR, First Information Report. Earlier, First Information Report is given in Section 154 in CrPC. Now, Section 173 in BNSS. If you are talking about the difference between CrPC from BNS, one of the basis is FIR. The zero FIR concept is first time introduced. So the earlier CrPC, this concept was not recognized. And FIR is mandatory in the case of the cognizable offense. The judgment is relating to Lalita Kumari versus Government of UP 2023. Primarily, investigation relating to FIR is not required in the earlier CrPC, but it is now permitted in BNSS. Now, third point of difference is investigation procedures. What was the investigation procedures in CrPC, and now what is the procedures continued in BNSS? Earlier, Section 156, 157, 161 and 164 is completely devoted for the investigation procedure in CrPC. Now, in BNS, Section 175, 176, 179 is completely based on the topic relating to investigation procedures. When we talk about the forensic investigation, it is not given in our CrPC, but nowadays it is given in our BNS. And it is one decided through the one landmark judgment, D.K. Basu versus State of West Bengal. Scientific investigation principle is given through this judgment. Now, recording of a statement, I am talking about the Section 161 under CrPC. Recording, if I talk about the recording, in CrPC it is written in a black and white form, but in BNSS it is maybe based on the electronic modes and audio-visual modes specified in Section 179 of BNSS. नेक्स्ट जो हमारा जो डिफरेंस है, हम अगर बात करते हैं इन्वेस्टिगेशन प्रोसीजर का, तो उसमें मुझे बताना पड़ेगा कि डाइंग डिक्लेरेशन अर्लियर इट इज गिवन इन सेक्शन 164 एंड इट इज a magisterial requirement. Now in BNSS it may be the electronic modes and specified in section number 185. Lakshman versus State of Maharashtra. Reliability of the dying declaration is completely based on the electronic modes when the investigation procedures is conducted. Next, my point of difference is arrest. When we talk about the ground or basis of the arrest under CrPC, we must refer to section number 41 and in compared to the BNSS, now it's covered in section number 35. A leading case law is Ernest Kumar versus State of Bihar, under which no automatic arrest is given unless there is a ground. Notice is required under BNSS. It is specified in section number 35, but earlier in CrPC It is introduced in 2008. Right of arrested person, if you are talking, right of arrest person is specified in section number 50 and 50A. And now it is covered in BNSS in electronic notice under section 37. If we are talking about the arrest, the police custody, the 15 days sum total is required, or it is specified in section number 167, clause number 2nd. And now in BNSS, the notice period may be 15 days and split over the 40 and 60, and specified in section number 187. And we are talking about the arrest. The one of the leading aspect is arrest of the women. Now, arrest of the women is specified in BNSS in section number 36. And arrest after sunset. Arrest after sunset is completely required, the order from the highest police authority. It is a judgment of Prem Shankar versus Delhi Administration 1980. Now, my next point is bail or under trial right. When we are talking about the bail, first, default bail. Section 167, clause number 2. In CrPC, this is specified. Now it is given in section 187, clause number 3. And leading judgment is Rakesh Kumar versus State of Assam, 2070. Default bail is a fundamental right under Article 21. Under trial release, it is specified in section 461A of CrPC, when the offender is spent the half of the sentences. Now it is specified in section 479 in BNSS. It includes the life imprisonment, and the imprisonment must not be exceed the 14 years. Bhim Singh versus Union of India 1985, and it becomes the fundamental right under Article 21. Now, the bail is allowed in manual form earlier. That means in CrPC, but it is now maybe in digital form. Now the trial procedures. Trial procedures, when we talk about the timeline, about the trial, it is not given in our CrPC, but in BNSS, 60 days for the charges and 90 days of the charges. And it is completely based on the speedy trial, which is given by the Husainara Khatun judgment. Now, electronic summons is not required for the trial procedures under CrPC, but it is a mandatory in electronic form in BNSS, which is specified in section number 60 or 70. Now the witness examination. Witness is examined under the CrPC. The physical form of presence is necessary in CrPC, but the video conferencing mode is permitted under BNSS through section 530. Praful Desai cases, leading cases are based on and it is incorporated in our BNSS. Summary trial. When we talk about the summary trial, which is specified in CrPC section 260 to 265, now it is expanded. Next, my topic is charge sheet and the police report. When we are talking about the charge sheet, it is given in CrPC section 173. Now it is specified in section 193 of BNSS, and it is based on the victims. Now it is a right of the victims to receive the copy of the charge sheet. And the supplementary report is allowed under CrPC, and under BNSS it is explicitly included in the BNSS. Victims' right is limited under CrPC, but in BNSS, section number 193 and 396 having the extended, and Malkarjun Kedagali 2018 cases are give the extra right to the victims. Now, victims and witness protection. Now I am talking about the victims protection. Earlier in CrPC, victims appeal is given in section number 372, but now in BNSS it is given in section 410. Victims' right is minimal in CrPC, but a strong right are provided in BNSS. And the witness protection is not codified in our earlier CrPC, but now it is a mechanism tools is given through the case landmark case law Mahendra Chawla versus Union of India 2018. Now I am talking about the evidence and technology. Electronic evidence is not a common basis for the CrPC, but in BNSS it is a fully integrated and recognized under section 530, and it is defined in section number 2, clause number 1, subclause H. Anwar versus PK Basir, in which the section 65B certificate is mandatory for the electronic form of the evidence. मतलब इलेक्ट्रॉनिक एविडेंस देने के लिए सर्टिफिकेट का देना जरूरी है, मैंडेटरी है. सॉरी. Electronic trial is not emphasized in our CrPC, and now it is allowed in our BNSS. Investigation is limited in our CrPC, but investigation is done, and it is also in the form of voice, and DNA and biological samples may be given. It means in BNSS is allow the broader area, it covers the broader area. Shalvi versus State of Karnataka 2010, and it must be given on the basis of the consent of the offender. Now point number 11, sentencing and penalty. Now one of the finest way to give the sentence in a community service. It is not given in our CrPC, but now it is recognized in BNSS through section number 4 of BNSS. Commutation. Earlier in CrPC, section 432 is particularly specified. In BNSS, mercy petition is given, and time bound it is given. It is specified in section number 472 and section number 474. Shatrughan Chauhan versus Union of India 2014. Sorry. Security proceedings and preventive action. When we talk about the security proceedings and preventing action, it means in our CrPC, unlawful assembly, section 144, this matter is covered. But in law, it is covered in section number 148 of BNSS. And important case law is Madhu Limye versus Subdivision Magistrate, 1974. Preventive detention. It is specified in section number 107 to 110 in our CrPC, but now it is covered in section number 124 to 128 in our BNSS. Now my next point is proclamation and attachment. When we talk about the proclamation, it is earlier specified in section number 82 of in CrPC. Now it is covered in section number 84, and it is based on the state of MP versus Pulton Malla 2005, strict compliance is needed for the declaration of proclamation. Now I am talking about the difference between attachment. Attachment is earlier given in section number 83, now it is given in section number 85 of BNSS. And electronic attachment is not specified in our CrPC, but electronic attachment is nowadays specified in BNSS. Now the basics of difference is plea bargaining. Just point number 14, plea bargaining. Earlier in CrPC, it is specified in chapter number 21A. Now it is covered in chapter number 20. If we are talking on the basis of the section number 265A to 265L is a basic concept relating to the plea bargaining in CrPC. But now it is covered in section number 304 to 314 in our BNSS. And it is based on State of Gujarat versus Natwar Hirachand ji, 2005. It is valid for the criminal justice reforms. Sorry. Now I am talking about the maintenance proceedings. Maintenance proceedings. It is earlier specified in section number 125 in CrPC, but nowadays this section is shifted in BNS, Bharatiya BNS, and it is a leading cases of the Sabanu case 1985. Purpose is very simple. CrPC is based on the welfare legislation, but in BNSS, welfare legislation in addition to relocation of the victims. Now, last, appeal and revision, point number 16. When we talk about the appeal, it is specified in section 372 to 401 of CrPC. Now it is covered in section number 410 and 410 to 450 of BNSS. If you are talking about the revision is earlier relating to CrPC, section 397 to 401. But in our BNSS, it covered in section 452 to 456 in BNSS. The two additional points I am quoting here, one is death sentence and mercy petition. The mercy petition is not given in detail in our CrPC, now it is given in our BNSS, and it covered in section number 472 to 474. And time-bound mercy petition process is given. And leading case law is Shatrughan Chauhan versus Union of India, 2040. Delay in disposal in the mercy petition is violation of Article 21 of our Indian Constitution. Next one is, I am talking about the death sentence and mercy petition. Execution rules in our CrPC is based on the jail manual, but nowadays it is codified. Sorry. The new provision is also introduced in our BNSS. New concept is completely community service, section number 4, and community service was in CrPC is not given. Electronic warrant or summons is earlier not recognized, but nowadays it is recognized. Mandatory forensic evidence, section 176 to 179 is not given in our CrPC, but it is given in our BNSS. And some video conferencing rules, which I am earlier discussed in section number 350 in BNSS. It is given, but it is not given in our CrPC. And the time limited for the trial is not specified in CrPC. Enhanced victims' rights are limited in CrPC, and the digital signatures are not recognized in our CrPC. Nowadays, it is fully recognized, and on the basis of the evidence will be collected against the accused. तो मुझे ऐसा लग रहा है कि all the pointer will discuss very easily, and it is a very clear-cut concept, and I think you all are understand the subject matters. Thank you very much.